I'm pleased to open the 8th session on contemporary issues on the role of the judiciary. We have 7 speakers, and therefore I will have to be very tight in maintaining the time. And I would like to open with Professor Claude Klein. Professor Claude Klein is a former dean of the Faculty of Law at the Hebrew University. He was born in France and then immigrated to Israel. His doctorate in law is from the University of Strasbourg, and in 1968 he immigrated to Israel and later became the dean of the law school at the Hebrew University. He teaches courses in constitutional law and history, and is active in the International Association of Constitutional Law. Professor Klein, please.
Thank you very much. Well, since I am apparently the French connection of this law school, I thought I would be able to talk in French, but I have been told that it is not possible. And I would like also to ask your indulgence for one more minute, hoping so. After all, your name is Hofnung, which means that we are looking for, or we hope, because I want to say a few words just to my friend Shimon Shitrit. I was not able to come yesterday evening, and I am very pleased to tell him my friendship, how much I admire him. And I like to remember that my first article in Israel, written in Hebrew in 1969, was written with his help. He was then a student at the Mishpatim law review held by the students, like in the United States, and he was very helpful. Thank you very much. Now to the theme. Apparently, even in this association, which is very important, and I admire what you have done, nobody speaks a lot about France, as if the French judiciary is completely apart. Well, it is apart for a certain number of reasons, but even when we started talking, and Shimon, you asked me to intervene here, I didn't realize the crisis going on the French judiciary in those days. The French judiciary, first of all, is different. I would like to say in different ways, but the first, of course, is the fact that there is the ordinary judiciary and the administrative judiciary. That is, that the judiciary is ordinary judiciary, which is criminal business, etc., etc. This is, of course, the most important, and we don't talk about the second one. Another question, which we shouldn't forget, is a fact regarding the recruitment of the judges, ordinary judges. Well, the French have invented a system. Everything is done through a competition. And there is a school for magistrates, so a student being 21, 22, 23, you can ask him and say, well, I'm trying to enter the school for magistrates, l'École nationale de la magistrature, which is, by the way, is not in Paris even, is in Bordeaux. And that's the way they are recruited, and it works not that bad. That's, of course. But if you look even at the paper yesterday, you are informed that a crisis is going on. Even so much so that President Macron had decided a few months ago already to establish, you know, French people like history, so everything is done through a reference to history. The States General of the French magistrature, which has been established and works in the following way.
There is a committee appointed by the government with members of parliament, etc. But everybody can participate in discussions which are held in various places in France, even those days. And at the end of a few weeks, that will be a few weeks ago, well, apparently with no connection to his elections coming up, of course. So the États Généraux, they will present the result of the reflection going on in France on the question. A second thing which is very important to know, something terrible happened a few weeks ago. An article, a petition was published in the French paper, Le Monde, which is the paper, and it was signed by 3,000 judges who protested against the way they are treated, against the way they have to work. They have the real mean to work. They don't have the help they need, and it provoked a real stupefaction in France when this was published. By the way, don't forget, last thing which I have to say about that in France, the École nationale de la magistrature and the recruitment of judges is also for the prosecution. The prosecution is considered as being part of the magistrate, of the judges, so far that, as you know, it's a great difference between, for instance, Israel, but all common law countries. At the court, okay, the judges sit very high, and the prosecutors are high, but they have to stand. That's the reason they are called the standing magistrates, and the other judges are called the sitting magistrates. But they are at the same level, whereas in Israel, as you know, the prosecutors sit like next to the defender, for instance, in a criminal case. Now, this is a terrible crisis, which actually the French people don't know how to handle. It's not a political one. What we hear here in Israel is not really, that doesn't apply. It's not political, it's really the means which the state has to raise and to put at the disposal of the judges. And it could be very expensive, but France pays a lot on this ground because trials are very long, even longer than in any other country where they also complain that, of course, trials are too long, but very often a trial can go on for years, and the French are really complaining about that. That is, have I taken up my time? 5 minutes more? Well, okay. So the French suffer very much from that, but also the judges. A lot of judges are leaving earlier, and even the recruitment at the École nationale de la magistrature has fallen down. That is a number of candidates. Okay, it's an entrance examination, or it's well, you can call it an entrance contest. Well, the French like the contest. If you want to be professor at your university, in law, there is a contest. So every year, the government says, well, we have 25 places for public law, and there are 200, 300 candidates, or École nationale d'administration, but this has been suppressed this year because I think that there's a problem of recruitment in France, which is different from what we can think. It's in the way that it is a social recruitment. Well, the best chances for somebody to enter those schools is to be a son or a daughter of somebody who has already been in that school. Not that much because the jury will prefer those or not, but because they have acquired the codes, the civilized codes, the cultural codes, and this applies also to the judges. And Mr. Macron is trying to change that. It's very hard. He has suppressed now the École Nationale d'Administration, where himself was a student in 2002. But it's not very well accepted in France, because this was called the meritocracy. Meritocracy, yes, on the merits, it's true. When you take somebody who has been the son of a former judge at the Cour de Cassation, so he knows the code, he knows how to write, etc. And the jury does not lie or does not prefer, it's just that the jury recognizes him as somebody who has already all the codes. Those are the questions which are raised right now in France, not only, by the way, for magistrates, but for all, especially also for the administrative magistrates, because this is the way you can enter later the Conseil d'État and so on. So this is a special crisis. Now, just a word about politics, because we cannot avoid it, okay? Just remember, you the following: France has introduced a Conseil Constitutionnel in 1958, and this Conseil Constitutionnel can review laws. Now, I remember in 1981, when Mr. Mitterrand was elected, he formed a government with a communist, and they decided to pass a law nationalizing banks, the large banks. And the Rothschild Bank was nationalized. So a case was brought before the Conseil Constitutionnel. Not that much because nationalization was not legal, it was very legal, but because of the compensation which was paid to Rothschild. And the Conseil Constitutionnel decided to cancel the law, and decided that it was not appropriate. What has been promised was not appropriate. So the papers came out and saying, well, the Conseil Constitutionnel costs the people in France 2, 3, 4 milliard francs. So sometimes the Conseil Constitutionnel, which is politically, by the way, appointed, but the majority can change, even so the Conseil Constitutionnel members are appointed for 9 years, but also there is some form of criticizing, but it's not as terrible as it is in Israel. Thank you very much.
Thank you very much, Professor Klein. It has been a pleasure to hear you, and we know each other for many years. And again, I'm still like to hear what you say on different subjects. Our next speaker is Professor Jonathan Entin from Case Western Reserve University. Professor Entin is Professor Emeritus of Law and Adjunct Professor of Political Science at Case Western Reserve University, where he served for nearly 8 years as the law school academic dean, and he has written extensively about constitutional law, administrative law, civil rights, and judicial independence. The subject of Professor Entin lecture via Zoom is Court Packing and Judicial Independence, an American Perspective. Professor Entin, please.
Thank you. And let me join everyone else in thanking Shimon Shatrit for inviting me and for doing such a fine job over the years on this important subject. Now, let me add that I'm going to be talking about, let me say that Myman Schwarzschild earlier this morning referred to court packing in the United States. Let me just say a little bit more about what has led to this discussion. The people who want to expand the size of the Supreme Court are responding to what they regard as sharp dealing by Republicans in the US Senate, who in 2016 refused to act for just about the entire year on President Obama's nomination of a replacement for Justice Anton and Scalia. But in the fall of 2020, in the weeks leading to the presidential election, they expedited the confirmation of Justice Amy Coney Barrett to succeed the late Justice Ruth Bader Ginsburg. And the critics claim that as a practical matter, the Republicans stole 2 seats on the Supreme Court, and they want to expand the court to compensate for that. Now, I want to say a couple of things about this. First of all, the arguments surrounding this idea have been couched almost exclusively in partisan terms. We'll see that the Supreme Court in the past has had its size changed a number of times, but the arguments in those situations have turned on institutional factors, the efficient functioning of the Supreme Court and the relationship of the Supreme Court to the lower courts. The second point to make is that politics have been pervasive in Supreme Court appointments, even when the size of the court has stayed the same. Every president back to George Washington has considered partisan and philosophical aspects in making their appointments, and the Senate has been more or less deferential in response to the president. Now, for most of the history, which is summarized on this slide, the discussion has focused around decisions that the very first Congress made in the Judiciary Act of 1789. That law created 3 federal courts: the Supreme Court, circuit courts, and district courts. Now, those lower courts are different from the kinds of lower courts we have now, but the key thing was there are these 3 courts, but only 2 sets of judges. The district courts were staffed by district judges. The Supreme Court was staffed by Supreme Court justices. The circuit courts had no judges of their own. Instead, they were staffed by district judges and by Supreme Court justices who rode circuit. That is, they spent a lot of their time on the road at a time when travel was physically arduous and very time-consuming. And circuit riding was popular, to say the least. But Congress structured the court, so the Supreme Court, so that it could have its justices riding the circuit. So at the beginning, there were 3 circuits. The court had 6 justices, so 2 justices were riding in each circuit. As I said, that was controversial and burdensome. And in 1801, Congress responded by passing a law that reduced the size of the Supreme Court from 6 justices to 5. Didn't remove anybody, just said the next vacancy won't be filled. But that law eliminated circuit riding altogether. So the idea was the court didn't need as many justices because it had less to do. And to staff the circuit courts, the 1801 law replaced the circuit riding justices with new circuit judges for the first time. Well, and that's the way the 1801 law was debated for the most part. But there was more going on here. This law was not adopted until after it was clear that incumbent President John Adams had lost his reelection campaign to Thomas Jefferson. And the Jeffersonians regarded this as a political attack on them by preventing Jefferson from appointing Supreme Court justices, at least for the time being, and setting up a group of circuit judges who were likely to be very skeptical about Jefferson's policies. And so in 1802, at their first opportunity, the Jeffersonians repealed the 1801 Act, but they also recognized that the old system had problems. And so they expanded the number of circuits from 3 to 6. So now each justice had an individual circuit to ride. And that apparently ameliorated at least some of the burdens of circuit riding. And then as new states came in, the Congress would create new circuits to accommodate the new states and add justices to ride those circuits. And so in 1807, we went to 7 circuits and 7 justices. In 1837, we went to 9 justices and 9 circuits. And finally, in 1863, during the Civil War, Congress passed legislation that resulted in 10 justices who rode 10 circuits. Okay. It soon became apparent that 10 justices might be too many for a variety of reasons. And so in 1866, Congress passed a law that reduced the size of the Supreme Court to 7. Again, did not remove any sitting justice, but said, we just won't fill the next 3 vacancies until the court gets down to 7. And the 1866 law reduced the number of circuits from 10 to 9. Now, at this point, there actually were only 9 sitting justices because one of the 10 had died. And so at least for the time being, we had restored the balance between the number of justices and the number of circuits. But by 1869, it became apparent that a 10-judge court or an even-numbered court might be problematic. And so in 1869, Congress passed a law that said there would henceforth be 9 justices. Indeed, at that point, there were 8 because a second justice had died. But the 1869 law also authorized the appointment of 1 circuit judge in each circuit. That cut back on the circuit riding responsibilities of the justices, and indeed most justices stopped circuit riding. Circuit riding was formally eliminated in 1891, but since 1869, the authorized size of the Supreme Court has been 9. The only serious effort in the 20th century to change the size of the court was in 1937 with President Franklin Roosevelt's failed court packing plan, which he proposed because he was really angry that the Supreme Court in his first term had struck down many of his New Deal initiatives. But Roosevelt couched his court packing plan not out of opposition to the court's decisions, so much as out of a sense that 6 of the justices were over 70 years old. They were slowing down, they were inefficient. The court needed new blood. He made institutional arguments. They were, of course, pretexts. People understood what was going on. His plan failed. My point is that in virtually all of the period leading up to the recent proposal to pack the courts, to pack the Supreme Court, the arguments have rested largely on institutional concerns. At this point, the argument about increasing the size of the Supreme Court has been couched almost exclusively in partisan or ideological terms.
Professor
It's
Entin?
important to recognize that that the proposal to increase the size of the court is a response to what the proponents, as I said, regard as sharp dealing. But it seems to me that this whole episode raises some really troubling questions. The proposal to increase the size of the Supreme Court parallels larger debates about the role of the Supreme Court. In the long run, this is a bad sign, even though I think that the prospects for increasing the size of the court are virtually nil. Thank you.
Our next speaker, and I kindly ask you to be precise on time, no more than 11 minutes. So our next speaker is Professor Giuseppe Franco Ferrari from Bocconi University in Milano. Professor Ferrari is a senior professor of constitutional law at the Department of Legal Studies, and is also the vice president of the International Academy of Comparative Law. Professor Ferrari, please.
Good morning, everybody. It's a real pleasure to meet so many friends again. Thanks, first of all, to our leader, Shimon Shitrit, for the organization of the event. Actually, I had carefully planned a trip to Israel, but it proved impossible to be there in presence. But I'm sure that our works are going to be useful as always. I put down some ideas concerning the position of the Office of Public Prosecution in Europe. It would have been much harder to put down a complete worldwide view research concerning the same topic. So I will simply describe some of the most important models of organization of the prosecution office in Europe, starting with the fact that after the Lisbon Treaty, whose Article 2 binds the Union and its members to observe the principle of rule of law, and after the publication of the report of the Commission about the strengthening of the rule of law in Europe, Communication 2019 number 343, and after the introduction of the preliminary ruling procedure that has reinforced the dialogue between national jurisdictions and the European Court of Justice, a new officer of public prosecution has been created, the European Public Prosecutor Office, EPPO, that will be competent to the investigation of crimes that are related to the financial interests of the European Union directly in the territory of the member states that take part in the extended cooperation introduced by Regulation 2017-1939 of the Council. The European prosecutors will submit the results of their investigations to the national judges. Such event follows the recommendation of the Organization for Economic Development, OECD, which follows Article 5 of the Convention of 1997 against corruption, that investigations on such topics must not be influenced by considerations of national economic interest or of personal nature. The model adopted for the new structure closely resembles the Italian one, an independent office looking for evidence in favor or against the investigated or suspected persons, and whose activities are bound to the principles of legality of criminal action. The EPPO has been operating since the spring of 2021, keeping under control the enormous economic resources that the Union is transferring to the states in the emergency situation, which goes under the name of Recovery Fund. The European prosecutors shall be included in the prosecutorial structure of the member states as active members with total equivalence of powers. A lack of cooperation by a state might activate an infraction procedure by the Commission. The choice of this model does not imply an obligation for the states to conform to the model in organizing their offices. At most, there will be some cultural or moral influence of the EU model on future state reforms without any binding effects, neither at the moment nor in the future. In Europe, at the state level, by now there have been several models of relationship between prosecution, judicial power, and executive power. The most important ones are three and can be qualified. The first one as of total independence, and it is called the monist system, represented by the Italian case. The second one is the lesser independence model, represented by Germany and Spain. And, and the third one is the model of intermediate independence, which is represented, for example, by the Low Countries and Belgium. Starting from Germany, Title 10 of the Statute on the Judicial Organization, as interpreted by the Federal Constitutional Tribunal, underlines the independence of the public prosecutors. The prosecutors belong to the executive, but contribute with the courts to carry out the functions necessary to the achievement of justice. A double hierarchy puts federal prosecutors under the Minister of Justice of the Federation and the land prosecutor under the Land Minister of Justice. The two pyramids are independent from one another. There is no one magistracy as a body, but two different judicial functions. Prosecutors are administrative civil servants within the executive power. In each structure, there is a hierarchy, since the chief of every office can impose its directives upon his or her delegates or helps. However, the prosecutor often ends up working as a judge, since several urgent procedures include the possibility for him to adopt judicial or semi-judicial measures. In Spain as well, the Constitution of 1978 created an independent system of administration of justice, which is regulated by Article 124. The Organic Law 50 of 1981, Estatuto Organico del Ministerio Fiscal, provides the Office of Public Prosecution with a regulation totally different from that reserved to judges. Among other things, a Consejo Fiscal, different from the Consejo General del Poder Judicial, and elected in its majority by the members of the Office of Public Prosecution, takes care about the administrative management of this body. The structure of the office is clearly and openly hierarchical, under the direction of the chief prosecutor, appointed and revoked by the king after proposal by the government, after consultation with the Consejo General, the high superior council of the magistracy as a whole. The chief prosecutor guarantees the unity of the action of the office and takes care of the structure, working, and disciplinary action concerning prosecutors. In theory, he should not have decision powers, but only an advisory role in its relationship with the general prosecutor. Formation, selection, evaluation, and promotions of prosecutors and judges are subject to different rules, nor is there any chance of moving from one career to another one. Hierarchical independence is evident in instruction circulars and even the possibility for prosecutions of being moved from a group of investigation to others. Prosecutors can express opinions different from those of the office or of its chief on the occasion of office meetings, both in oral or written way. The other extreme of the range of solutions is represented by the Italian system. The prosecutorial function and the judicial one together compose the judicial power as a unitary order. This is the constitutional definition, and enjoy the same guarantees. The career is the same since the beginning, and the professional selection allows the incoming young members of the judiciary to choose the position they prefer to take in one or of the two careers. But it's impossible to move from one, but it's possible to move from one to the other after 3 years. Prosecutors and judges are equally immovable, and the High Council of the Judiciary is empowered of their appointments, career progress, disciplinary procedures. The independence is similar toward the outside in the relationship with the minister, who cannot completely interfere with the work of prosecutors, and inside the judiciary, thanks to the decentralized and not hierarchical organization of the structure. Magistrates do not differ, but for the diversity of their function, states Article 107 of the Constitution. Therefore, there is no magistrates do not differ, but for the diversity of their functions, no subordination between general prosecutor, district prosecutors, office of public prosecution in the local courts, nor does the chief prosecutor of a local office really own any hierarchical power on the other members of the office. I only have to add that after Mani Pulite, the operation at the beginning of the 90s, the prosecution has achieved an enormous power with investigation on parties and prominent members of the political community, with a self-referential attitude, with a strict proximity to politics and media, with a growing sclerotization of the division into ideologically characterized groups that are called the streams. In the last years, there has been talk of the need of a reform in order to remedy such defects, but no results have been concretely achieved until now. An intermediate model can be found in countries such as Belgium and Holland. In these legal systems, the members of the prosecution office are at the same time civil servants, as such subordinated directly to the national executive, and consider its representatives and participating to the carrying out of judicial function, and therefore considered magistrates. The local authors speak of double dependence or of functional duplication to describe their status. I don't have time to enter into details concerning the Belgian or Dutch organization of the prosecution office. However, I have written down some pages that I will be glad to provide to the organizer for distribution if needed. To answer the question put in the morning by Lord Thomas, I don't feel sure it is possible to organize an ideal model of organization for the prosecution office. It depends on cultural and traditional reasons. I only would not suggest to generalize the Italian system, such as the European Union apparently has tried to do in regulating the new EPPO. At least I would not suggest to extend it to apply it to different systems unless the local conditions are completely different from the Italian ones. Sorry for not being able to enter in more details. I hope there will be future occasions to come back to this topic. Thanks again.
in the program, and our next speaker will be Yaniv Roznay from Reichman University. Let me say a few words about Yaniv Roznay, who are very young and promising professor of law at Harry Roznay Law School at Reichman University. Professor Roznay is also the co-chair of the Israeli chapter of International Society of Public Law, and is recently publishing in a Furrier space. Now, Professor Roznay is about to speak on democratic erosion and judicial independence as an unattainable principle. Professor Roznay, please.
Thank you very much, dear Professor Hofnung. If I'm very young, then it was already worth coming to this conference to get this compliment. I thank you all very much. It's a great honor to be part of this. And congratulations to our dear Professor Shimon Shitrit. Mazel tov for everything. So let me, it's a short time, so let me be quick. I don't think I need to elaborate on this. And everyone who has opened a constitutional theory or political science book in recent few years knows that our world is experiencing a crisis of constitutional democracies. The 2021 Freedom House report shows that 2020 marked a crisis of democracy and recorded the 15th consecutive year of declining global freedoms. In fact, the proportion of not free countries is now the highest it has been in the past 15 years. So the world is experiencing a crisis of democracies whereby populist leaders are eroding the democratic order. And as Levitsky and Ziblatt write in their book, the assassins of democracy now use legal, subtle, and gradual means to kill it. Now, one of the great risks of this populist trend is to the principle of judicial independence. Populist regimes are not so bothered with legal constraints because they can change the law. They are bothered by independent institutions that can block their powers, such as ombudsmen, gatekeepers, and most importantly, courts. So populist regimes argue that courts are political, and they try to threaten them, undermine their authority, and eventually capture them. As Ginsburg and Hook correctly claim, constitutional provisions on judicial appointments, removal, and salaries are rarely immune from constitutional amendments. Hence, it is typically fairly easy for a would-be autocrat to first gain control of the judicial apparatus and then turning to amend other features of the Constitution. Indeed, a central mechanism at the service of those leading the populist process is formal constitutional amendments. Accordingly, limitations on amending certain constitutional rules, values, or institutions that are regarded as fundamental for the constitutional order may be especially relevant to battle democratic erosion. Such limitations may be explicitly enshrined in the Constitution. Judicial independence, for example, is protected as an unamendable principle in the constitutions of Angola, Cape Verde, Mozambique, Portugal, Romania, and Timor-Leste. Such limitations may also be judicially imposed when the court derives such limitations implicitly from the Constitution, declaring that certain changes are strictly prohibited. So the most famous example is India, where the Supreme Court has held that the parliament cannot amend the basic structure or features of the Constitution, and included judicial independence within the list of such basic features. So the unconstitutional constitutional amendment doctrine, or basic structure doctrine, shifts the locus of constitutional change from those political authorities that are entrusted with the power to change the Constitution to the judiciary. This is part of its strengths, but it is also part of its weaknesses. In an era of populism and democratic erosion, when politicians realize that the ultimate decision regarding constitutional changes rests with the judges, then courts may be threatened, pressured, or packed in ways that either undermine their ability or willingness to deploy the doctrine, or worse, abuse the doctrine. So, for example, in Turkey, a set of constitutional amendments were used by the ruling party to expand the size of the Supreme Council of Judges and its constitutional court, enabling their packing. And as we've heard earlier in Hungary, constitutional amendments expanded the size of the court, ousted the president of the Supreme Court, disempowered the existing Judicial Council, and basically created a new institution with powers over ordinary judicial appointments. Accordingly, even if in theory the doctrine may be a useful tool against abusive constitutionalism, the ability to pack the court and control it severely undermines its utility. It is not only that the doctrine in the era of populism is useless, it is even worse. As a powerful tool that can override constitutional provisions, with a packed court, this powerful judicial mechanism is now at the hands of the political leaders, providing them another powerful tool to perpetuate their stay in power. Consider, for example, recent events in Nicaragua, Bolivia, and Honduras, where courts have used this doctrine not to limit presidential term limits or hinder attempts to prolong the term, but in fact removed presidential term limits at the service of leaders, thereby allowing them to be re-elected. These examples actually demonstrate how an abuse of the doctrine by a captured court may promote constitutional changes that threaten liberal democratic constitutionalism. In light of all this, I want to turn to my final and central point. There appears to be a growing trend towards court employing basic structure doctrines to strike down constitutional amendments for violating unamendable principle of judicial independence or to protect the judicial power. These cases fall along the following spectrum. On the one hand, we see judgments that are justifiable on democratic grounds. They are necessary to protect judicial independence against abusive constitutionalism. On the other hand, we see judgments that serve to reinforce judicial supremacy or otherwise simply to advance the court's institutional self-interest. Where a particular judgment falls on this spectrum requires a careful analysis of the relevant society's constitutional politics and institutional context. Consider the following examples. In India, as Professor Shetrit mentioned earlier, in 2016, the Supreme Court invalidated a constitutional amendment that created the National Judicial Appointments Commission, which actually divided the judicial appointment among justices, political actors, and eminent persons. Now, because judges were to occupy only 3 out of 6 places on this commission, the court concluded that the commission unconstitutionality undermined judicial independence, which is part of the Constitution's basic structure. Now, this judgment has been heavily criticized, especially since it neither offered a convincing explanation why the Constitution requires judges to have the final word on appointments, nor addresses the serious flaws with the collegium system. Professor Abaratne, for example, argued that this judgment fails to establish how the basic structure of the Constitution is violated by a more deliberative, institutionally independent judicially appointment procedure. It's unclear. So the judgment appears to be motivated largely by institutional self-interest. The court was simply unwilling to relinquish its monopoly over appointments to the higher judiciary. In Bangladesh in 2017, the Supreme Court invalidated the 16th Amendment to the Constitution, which made judges removable upon a presidential order supported by 2/3 majority in parliament, rather than on the recommendation of the Supreme Judicial Council that actually consisted of Chief Justice of Bangladesh and the 2 most senior justices. Now, on its face, this case appears to be like the Indian one, but upon a closer look, it is more justifiable on normative grounds. This amendment would have vested the judicial removal power entirely in political hands. Moreover, context is important. Bangladesh has experienced 2 periods of martial law, an emergency rule that, if there's a music in the background, thank you, that an emergency rule has been declared 4 times, each resulting in the suspension of fundamental rights. So I think that these contextual factors provide a stronger justification for the Bangladesh Supreme Court basic structure enforcement rather than its Indian counterpart. A few more examples. In Colombia in 2016, the same year, the Constitutional Court, using the constitutional substitution doctrine, invalidated 2 constitutional amendments, reforming the judiciary and creating a commission for prosecuting criminal and disciplinary offenses by judges. I think also in these 2 decisions, the use of the unconstitutional amendments doctrine was problematic because both seem to confuse the political inconvenience of the amendment with the substitution of the Constitution. In Malaysia, 2 recent federal cases invoke the basic structure doctrine. While neither judgment strike down a constitutional amendment, they powerfully assert that judicial independence constitute part of the Constitution's basic structure. And it remains to be seen whether and on which grounds, on which issues the federal court will apply this doctrine in the future. But based on the evidence thus far, it appears to be using the doctrine only when its own institutional prerogative were at stake. Finally, in Slovakia in 2019, the Constitutional Court struck down a constitutional amendment that required all judges and candidates for judicial offices to be examined by the National Security Authority. The court held that the Slovak Constitution has a substantive core comprising several principles, including judicial independence. It then invalidated the amendment on the grounds that it would violate judicial independence. As in Malaysia, it is too early to see how the court will further develop this doctrine. And in any way, following this case, the parliament amended the constitution so as to prohibit judicial review of amendments on substantive ground. So just to conclude in 30 seconds, one of the challenges of the unconstitutional constitutional amendments doctrine is that in the populist era, court packing weakens the judicial struggle against democratic erosion. Accordingly, in a democratic erosion context, the court, I think, should be especially aggressive in protecting their independence. But this, again, might appear in conflict, I'm finishing in 30 seconds, might appear to conflict with legitimacy considerations, as the court may be regarded as acting to preserve its powers and enhance its self-interest. However, preserving judicial independence is vital to the survival of democratic order, and therefore, I think courts should be especially militant in protecting their own independence, even against constitutional amendments. Thank you very much for listening.
I myself will be the next speaker. My name is Menachem Hofnung, and I'm teaching at the Department of Political Science at the Hebrew University of Jerusalem. The article which I present is written by myself and by Dr. Nirat Mor from Tzfat Academic College. And the title of our paper is Public Trust in Israel Judiciary, the Effect of Political Polarization. Israel Judiciary Authority in general, and the Supreme Court in particular, have been under repeated attacks, especially in the last decade, but actually it goes on for about 3 decades. And what we do when we try to analyze the effect of the polarization and public opinion is to do 3 things. First, historical analysis of the Supreme Court rulings on public disputes, and the political processes that led to decline in trust in Israel's judicial system, quantitative analysis based on surveys of the Israel Democracy Index carried out in more than 20 years by the Democracy Index of the Israeli Democracy Institute, and then our findings and conclusions. Questions. First one is, why the power of Supreme Court become a center of political conflict? Is it possible to identify support and opposition to the court among distinct groups in Israel public opinion? And the third one, is this conflict symbolizes an ideological polarization of the political system itself? If we go back to the beginning of history, to the beginning of the state of Israel, we can see that the state came into being in not very hospitable situation. It came to being during a war of independence in 1948, with supreme authority in the legislature, a parliamentary system in which the executive controls the legislature, no constitution, no formal power of judicial review, no guarantees for human rights, and permanent state of emergency. This is not a very hospitable situation to nurture a democracy. In such situations, the real or the only balance against abuse of powers had been the Supreme Court. Initially, the justices were selected by the government, but since changing the law in 1953, a committee was put up, and that committee takes some of the power that had before in the hands of the politician. The committee that recommends appointments of justices is composed of 2 cabinet ministers, 2 Knesset members, 3 Supreme Court justices, and 2 lawyers elected by the Israeli bar. So if you look at the composition, the professionals are 5 out of 9, and politicians are composed or having 4 seats, which means that professionals do have the majority. Now, fast forward, and we jump to 1967 and the 6 Days War. Until that time, the Supreme Court was important in the history of Israel, but most of its decision did not arouse public debate or conflict, even much later. When I became a student of the law school, I remember that nomination of the justices to the Supreme Court could be found in the back pages of the daily newspapers. But the war in 1967 had a profound effect on the Israeli political system and also on the legal one. The occupation of the West Bank, Gaza, and Sinai at that time created 2 legal systems under one government. Israel of pre-1967 borders and the annexed Jerusalem having one legal system, and the territories another one. There was also the question of settlements. Are they legal under Israeli law, under international law? And since then, more and more questions came before the court. One result of it was almost immediately judicial oversight of military action, which was not, well, somewhat of the case before, but not on that magnitude. Gradually, after the 6-Day War, the Israeli political system also changed, in which the major debate and the major alliances, political alliances, became between hawks and doves, or leftists and rightists, depends on how you look at it. And in the 90s, 80s, we had 3 successive electoral campaigns in which the margin between the 2 main blocs was no more than 3 seats. At that time, minor parties became the swing vote. And the government of the day found it much more convenient to move political questions into the decision of the court. Because in such a situation, it would not endanger the existence of the ruling coalition. The willingness of the court to look into such matters, especially security-based arguments, encourages more and more people to go to the court and to submit petitions. And gradually, the Supreme Court was perceived more and more as a veto player. A veto player means that no decision is becoming final unless it is given a stamp of approval by the Supreme Court. The political backlash against such situation took time, but it arrived. And it arrived in the 90s, and since then we do have a situation of political parties campaigning in each electoral cycle, not only against other political parties, but against the court. It is main feature of their political campaign. The backlash is that professional practices such as nomination of judges and division of cases between the justices became the focus of attention, and they also affect the independence of the judiciary. And from here we go to the survey itself, and then to the conclusion. Our dependent variable is trust. And by trust, we mean actually the question, to what extent do you trust the Supreme Court as an institution? And now, the results are quite striking. If you look at support of the court by religion, you can find that the minorities are having much more trust in the court than the Jewish majority. The Jewish majority in 2020, about 51%. The Muslim, Christians, and Druze, between 60 and 72. If you look at trust by political affiliation, you can see that the left trusts the court much more than the right. And the most striking one is if you look at the Jewish population. And according to the level of religiosity among the Jews, why secular supports the court by 71%. If you move to traditional, it drops to 60, national religious 43, and ultra-Orthodox only 6%. We can see the same phenomenon also by socioeconomic status. The more well-being you are, you tend to support the court. If you don't earn that much, and the main feature is the ultra-Orthodox or the Haredim, which do have a very low level of support to the court, and they are the less exposed to the decision of the court. All the decisions that they can see is through the mediators. It is not reported in the ultra-Orthodox community. Now, the effect is resembling other countries. We are not there yet, but we can see support for the same notions as countries that were successful, if you can use that word, in limiting the power of the courts, such as Russia, Turkey, Hungary, and Poland. If I try to come to the conclusion, and I do it very fast, I suggest you read the draft paper that we added to the proceeding of the conference. The Supreme Court is recently becoming much more careful in review of executive and legislative act. The Supreme Court has maintained its impartiality and political relevance, but is no longer insulated from political pressures that may affect the outcome of sensitive legal cases. Court independence is an issue again, as the court has to balance not only what is written in the law, but also the political implications of one decision or another. Thank you very much. And I would like to move now to our next speaker. And we do have two more speakers on this panel, and then we open the floor for conversation. The next speaker is Gian Andrea Denser from Switzerland. He is an acting lawyer for almost 5 decades, and he, for the last 10 years, is the secretary of the International Association for Judicial Independence and World Peace. And Attorney Dancer is going to speak about the process of selecting and nominating judges in Switzerland. Please.
Hello from Switzerland. I would like to thank all the organizers for this very beautiful and substantive excuse me, my English for these sessions. I have recorded my presentation, but I can read it again. Perhaps it's better. So special thanks also for Shimon Shitrit and for Professor Chodosh for the organization of this event. So the title of my presentation is Challenging the Traditional System of Appointment of Judges to the Federal Supreme Court in Switzerland. The current constitutional regulation of the appointment of judges to the Federal Supreme Court is the following. The Federal Assembly elects the judges of the Federal Supreme Court. When appointing judges, the Federal Assembly shall take into account the representation of the official languages, namely German, French, and Italian. The term of office of judges is 6 years. The Judicial Commission of the Parliament advertises the vacant judgeships and examines the applications. It then proposes to the Parliament persons who are professionally and personally suitable for election. General elections to the Federal Supreme Court are held every 6 years. The Federal Supreme Court consists of 38 full-time judges. What immediately strikes the mindful follower of Mount Scopus standards about this legal setting is the very short tenure of judges. The fact that they must face re-election every 6 years, and the direct connection of the electoral body with politics. Similar regulations in the world exist only in 2 countries, namely Liechtenstein and Andorra. But worse is to come. There is the following soft law or tradition lived in Switzerland until today. First, Parliament unofficially allocates judgeships according to the party proportional representation, the distribution key based on the strength of the parties represented in the Parliament. The judges, second, the judges, if then elected, must pay an annual tax to the party porting them. This is called party or mandate tax. Depending on the party, it is between Swiss francs 3,000 and Swiss francs 26,000 on a salary of 356,000 Swiss francs per year. This tradition was hardly known to the Swiss people. For the most part, only those persons directly involved in the appointment of judges knew about this practice. Giuliano Racioppi, an administrative judge of Grisons, who has done an excellent study of this tradition, calls this practice Europe-wide and probably unique in the world, and to be in conflict with all international standards of judicial independence. This practice has not gone unnoticed by critical foreign countries. As early as 2006, the Venice Commission of the Council of Europe stated in its opinion number 403, quote, "Appointments of ordinary judges are not an appropriate subject for a vote by Parliament because the danger that political considerations prevail over the objective merits of the candidate cannot be excluded. Greco, Group of States Against Corruption, which includes 50 states, also recommended the following in the Switzerland Evaluation Report of December 2016, quote, therefore, Greco recommends, first, abandoning the practice whereby judges of the federal courts give a fixed or percentage of their salary to political parties. Second, ensuring that the Federal Assembly does not justify the non-re-election of judges of the Federal Court on the basis of decisions made by them. Third, considering the modification or abolition by the Federal Assembly of the re-election procedure of these judges. In its first compliance report on Switzerland, published in 13 June 2019, Greco concluded the danger that judges could be voted out of office for political reasons was still present, and the maintenance of the mandate tax to the political parties still violated the principle of judicial independence. There were also critical voices in Switzerland. Transparency International Switzerland, for example, made the following pertinent observations already in its 2013 overview, quote, in economic terms, therefore judges in Switzerland must de facto buy their judgeship from a political party cartel. And other quote, action is needed to legislatively prohibit mandate taxes as a step toward improved judicial independence. Examples of attempt of political influence in a case concerning administrative assistance to the United States of America, so-called UBS, it's the bank proceedings. One party criticized the federal judge of its party affiliation because he had not ruled along party lines. In 1993, federal judges had to accept considerable losses of votes in the course of their re-election. They had participated in a decision according to which crucifixes in public schools violate the confessional neutrality of the state. Probably the most blatant case occurred in September 2020. It concerns the case of Federal Supreme Court Judge Donsala. He was elected to the Federal Supreme Court in 2008 on the recommendation of Swiss Popular Party, a right-wing nationalist party in Switzerland, which is the strongest party in parliament, with 1/4 of the seats. 12 of the 38 judges of Federal Supreme Court are members of this party. For the re-election of September 23, 2020, Federal Judge Donsala was no longer nominated for election by his party. However, he was nominated for election by the Parliamentary Judicial Commission. The rift between the party and Donsala stems from a Federal Supreme Court ruling that allowed the Federal Tax Administration to transfer information in some 40,000 UBS clients to France. This ruling in July 2019 came down to a 3-2 vote, with Donsala voting in favor of the data handover. Back in 2015, Donsala was involved in a ruling in which the Federal Supreme Court found by the 4 votes to 1 that the agreement with the European Union of the free movement of persons took precedence over national law in implementing the mass immigration initiative. The dissenting vote came from from a judge of this party, but not from Mr. Donsala. Before making its decision not to renew the candidacy of Judge Donsala, the parliamentary group of this party invited him for a hearing. The party expected him to take a kind of political oath of disclosure and to promise to follow the party line. He denied this, and he said, for a judge, it is out of question to apply a party platform when judging. And he said the party was taking the judges into a stranglehold, which he does not longer accept. Now, Mr. Gasser, in May 2018, launched an initiative for the partial revision of the federal constitution, in which he proposed the following amendments. The term of office of judges ends 5 years after reaching the ordinary retirement. It is 70. The judges shall be selected by lot. Admission to the lottery shall be decided by a commission of experts whose members shall be elected in a single term of 12 years. This amendment was voted on in November of last year, and the Swiss people rejected this initiative in a referendum with a voter turnout of 64%, 2/3 against and 1/3 pro this revision. It is interesting to note that Switzerland has recently been ranked among the top 5 countries in international ranking of the de facto judicial independence, while in the formal assessment of judicial independence is far behind, in 62nd place out of 71. After the initiative was rejected, Mr. Gasser immediately declared that he would repeat the initiative in 3 years. So certainly you will hear from us rather soon. Thank you very much for your attention.
Now to our last speaker in a very packed panel, Professor Anton Cooray from London City University. The floor is yours, and please keep in time because we like to leave a few minutes for questions and answers. Professor Cooray, please.
Let me first start by thanking Shimon for organizing this meeting. I have known Shimon since 1992, and he has always been a very kind, generous, good friend. And he would never refuse any invitation for any worthwhile project. Shimon, it has been a great pleasure knowing you all this time, and I look forward to visiting Jerusalem sometime soon, because my wife, my 2 daughters say we must see Shimon. So I hope one day, maybe next 2 years or something, we'll be able to visit you and just show how we appreciate your friendship. I followed the proceedings yesterday and this morning, and I'm very pleased with what has been said by various speakers. What I wish to talk about now is not the basics of practicalities or the mechanisms of judicial independence, but how the judiciary interacts with society. I divide this into judicial intervention in private sphere and public sphere. Now, in the private sphere, there is very little room for political disagreements. because the court is settling private disputes. Now, in that area, what people would expect from the judiciary are three things. One is that the judges are unbiased, that they give a proper hearing to the parties. Number three, most importantly, that the judges give a reasoned judgment so that people understand how in the future their lives can be conditioned on those decisions. But this does not mean that in the private sphere, there is no room for conflicts between politicians and the people. Take, for example, the question whether there must be marriage between people belonging to the same sex. Now, in such a situation, there will be a conflict between that minority of the people. I remember Professor Hofnung referred to the popularity or the acceptance of the judiciary, Supreme Court among people. Minorities have the highest acceptance level. That's because when the government passes a policy, it works according to the wish of the majority of the people. But the judiciary is not that way democratically accountable. Therefore, they are able to rely on well-established principles of justice, fairness, equality in deciding a case. Now, that would put the government of the day and the judiciary at loggerheads. Not because the judiciary is conflicting with the legislature or the executive, but on a policy level. Now, in one of the leading cases, the Hong Kong Court of Final Appeals said, what is fair and just is not decided by the majority of the people, but it is decided by age-old principles of justice and fairness. Now, when we move to the public sphere, we have major issues there in relation to the interaction between the judiciary and the legislature and the judiciary and the executive. In most countries where there is no paramount constitution, the conflicts are between the administrative action and the response of the judiciary. Now, in those areas, as well as where there is a written constitution, one of the issues would be what is the demarcated area for the administration and the legislature, which has to be immune to some extent from judicial intervention. That would be the area of policy making. Now, we all know that generally courts differ to the view of the government on policy matters, as well as they are willing to give a margin of appreciation or margin of discretion to the government in areas of policy making. However, when a policy is made, although the judiciary will not question the merits of that policy, the courts do intervene if they feel that the policy in question is not legal, that it is not made within the permitted bounds. Now, this used to be called in common law the ultra vires doctrine. But in the recent years, there has been a movement away from that on the basis that the legality of administrative action is not solely dependent on the administration working within their legal powers, but on the ground whether there has been a breach of the rule of law. Now, this was something that was debated greatly between people like Christopher Forsyth and Don Oliver of the University College London. And the generally accepted view today is that the courts have a wider power over administrative action. Now, this actually took color, I think, from countries which had written constitutions, the Commonwealth, like Australia, Canada, America, and even the new Commonwealth countries. That is that even if an administrator has acted within the confines of legislation, if the legislation itself is unconstitutional, then the courts had the power to strike down administrative action. So the whole basis was the wider concept of rule of law. Now, this is something that Shimon has in his mind, that the rule of law. How do we protect rule of law? Through ensuring that the judiciary is independent and
2 minutes, please.
It does its job. Since I don't have much time, let me just wish to say that in effect, the importance of the judiciary, that is the providing of the framework for acting within power, has to be seen more in the context of the judiciary's competence and its attitudes, their willingness to take decisions where the majority of the people may not agree with it. Not the government, but the majority of the people might disagree with their decisions. Now, if the courts have that confidence, they would be obviously confronting the government at one point or the other. But in order for the judiciary to be independent and not be lions under the throne, we need to ensure that judicial independence is protected through the various mechanisms that some of the speakers mentioned today and yesterday. And let me conclude again by saying that it has been my privilege to be a participant of this program, not so actively as in the drafting of the declaration, but I hope one day Shimon will ask me to participate, and then I will be happy to. Thank you very much for inviting me to speak on this occasion. Thank you.
Thank you, Mr. Chairman Menachem, for an excellent session and excellent presentations of this session. I want to make one comment. Throughout the conference, we have heard the issue of public confidence in the courts, that there is a crisis. And you explained that politics or the political division is, in fact, coming from the general discourse or public discourse into the judicial process or into the courts. And this is done by the fact that the scope of judicial function has been broadened. Let's take, for example, the British situation. For years, the British judiciary or the English judiciary has been viewed as a very restrained judicial branch. But look what happened in the last 2 or 3 years. We have intervention of the Supreme Court, UK, now it's called UK Supreme Court, not the House of Lords. Intervention in the Brexit case. We have intervention, also another major one, in the situation of the suspension of Parliament by Boris Johnson, and UK Supreme Court again intervened. So take even England, and you see major connection between politics and the judiciary. And this is a major challenge for the judiciary. On the one hand, there is expectation from the judiciary to solve legal constitutional disputes. On the other, we have a reaction from at least one part of the public that is against, and this brings the court into the general arena of dispute. I want to ask our friend our colleague, Professor Roznay, who is advocating the theory of unconstitutional constitutional amendment, and ask him the question how this question of involvement in politics is related to the issue of his agreement. Are we not going into too much political involvement, politicization, if we are going to go into this direction?
Okay, so I will defer to Professor Roznay, and then I may add a few comments of mine. Professor Roznay, please.
Thank you very much. Thank you, Professor Shitrit. I'll try to be brief in my response. I think you are very much correct in the sense that reviewing constitutional amendments would be the highest politicization of the judiciary, or the judicialization of politics, to be more precise, obviously. It turns the court as the final arbitrator of society's values, in a way. But I want to give the counterclaim. I think that this whole debate nowadays on judicial restraint is almost a myth, an illusion. Because when we look around the world in the context of populist constitutionalism, it seems to me that politicians will not be happy with anything apart from a court that is a rubber stamp. And you gave the UK as an example. Look at the UK court. No wide reasonableness doctrine, no power to invalidate legislation. In a European comparison, it is the weakest court. And it was enough to have one case or two that were dramatic to end the story and bring a huge political backlash against the court. So to my mind, in the context of populist constitutionalism, stories of judicial restraint are simply not enough. Like kids that you give them a finger and they want the entire hand, so does politicians in the context of democratic erosion will not be happy even with a restrained court unless it would be a court that is completely subordinated to the politicians. So if I have to choose among these two necessary evils, I choose a court with wide powers, even of judicial review of amendments, but they would have to use it very wisely and to be extremely restrained when exercising this authority, but they must possess it in the current context. Thank you.
I like to add that one of my observations, and I'm not sure that I do have a solution. I can say what is going on and what is wrong. I'm still searching for a solution. And I'll give you an example from my own experience. A couple of years ago, I was asked to address a crowd audience of religious educators. And I knew that they do have full stomach against the court. So first I asked them, what do you think about the Supreme Court? And then, attacks all over. After a couple of minutes of attacks, I then asked a simple question. Have any of you read one decision of Supreme Court in recent years? There were about 50 people in the room, one raised hand, and then he admitted that he read it in the newspaper. Okay, so the less the people are exposed to the decisions of the court, the more they do have an opinion about it, a negative opinion. Now, how can you treat something like that? I'm not sure that I do have the solution. But it is one problem of the polarizations of the political system. It affects the judiciary, and in a way, it also affects the decision of the judiciary because it has to take into account that such notion exists within the population in general. Professor Shitrit, please.
I want to add, I mentioned in the last session that we have to follow the principle of fine-tuning. And I think the more I think about it, fine-tuning which I wrote about first time in 1994 in my book, Justice in Israel, and I repeated it about the Israeli context in 2004 in another book, but this time in Hebrew. I think if we require the court to address this issue every time it decides to intervene, then it is possible that this question will be on the table, and they'll have to give reasons, like what Professor Cooray said. One of the principles of the judicial process is that court has to give reason. Now, to take your comment, assuming that we are able to use social media, general media, and so on, in order to educate the public about what we hear in the court, then that could also help. So on the one hand, educating, marketing the opinion of the court in a simple way, and on the other hand, asking the court to address this point, why they think they should intervene, and to lay down a principle that the principle of not trespassing the boundaries of between the court and the other branches.
It may work. I'm not sure that I do have the answer, but I think I know what's the problem. As for answer, I'm not sure. Any other comments before we conclude? Okay, so I would like to close the session by expressing my own thanks for Professor Shetrit. You probably, very few of you know, but Professor Shetrit had been my instructor while I was writing my PhD. That was many years ago. And since then, we maintained good relations. It was a tremendous conference in spite of the problems of the COVID and all the other problems. And the project that you carry on for 40 years is a very impressive one, and I hope we will have another fruitful conference in September this year at Claremont-McKenna College. Thank you very much, and thank you for your patience. We do have our next session within 30 minutes.